UNUM Paul Revere disability benefits for ischemic optic neuropathy caused by pregnancy complications. Now, UNUM and Paul Revere will seize for offhand comments during interviews with disabled policyholders for reasons to deny or terminate benefits, even though they may have paid disability benefits for a long period of time. And that's exactly what happened in the unfortunate case involving Dr. McNaughton. Dr. McNaughton was a diagnostic radiologist who was left with permanent electrical damage to her left eye. It's called ischemic optic neuropathy, and it was caused by pregnancy complications. UNUM paid her disability benefits for 10 years, agreeing she couldn't perform the material and substantial duties of her own occupation. Obviously, one has to have great vision in both eyes to review diagnostic studies and to render medical opinions about abnormalities that they may have observed. So what happened? Well, she had a discussion with UNUM, her carrier, and as we know, UNUM isn't in the business of paying long-term disability benefits regardless of how legitimate a claim might be. And McNaughton had begun working part-time in a supervisory, non-diagnostic position. During the call with UNUM, she offhandedly mentioned that she didn't have any restrictions or limitations in her current work. So guess what happened? UNUM seized on that comment and cut her benefits off. She appealed, and ultimately she ends up in federal court. The federal court notes that the denial was, predetermined, that she had been denied a full and fair review because UNUM Paul Revere had not given her an opportunity to rebut the report that UNUM had relied on and its conclusions. So on the first go around, the court granted a motion for summary judgment in her favor and unfortunately remanded the claim back to UNUM for a second bite at the apple so that they could get the denial right. Now, she rebutted the report, she submitted additional evidence, and guess what? UNUM denied it a second time. Are we surprised? I certainly am not surprised. But when we get it in front of the judge the second time, the judge is not so sympathetic and notes that the claim was denied on the basis that the inability to use one eye does not render a diagnostic radiologist disabled and that she had sufficient use of both eyes. Still doesn't make any sense. But using an arbitrary and capricious standard of review, the court's hands were tied. And while the court had issue with UNUM's conduct, the court found that there was substantial evidence in the record to support that a one-eyed radiologist could perform their occupational duties and that she had sufficient use of vision in both eyes, regardless of how limited it might be in one eye, to perform the material and substantial duties of her occupation. The judge noted that UNUM had their peer review physicians check off and comment on her physician's opinions about why she couldn't do her occupational duties. And the court noted that UNUM didn't have to accept the opinions of her treating physicians, notwithstanding the fact that her doctors had supported her disability claim. And as a result, UNUM was the beneficiary of this awful, arbitrary, and capricious standard of review to rob Dr. McNaughton of her disability benefits. What are the lessons learned here? The lessons learned here, unfortunately, are that the arbitrary and capricious standard of review is basically a license to steal. Two, that disability carriers don't have to accept the opinions of treating physicians. And three, that decisions don't always make sense. And by that I mean, if I was having a radiologist review my records, I would want a fully functional physician who had acute eyesight, not one who was able to use both eyes and had some visual issues. Wouldn't you want to have the same in your situation if you had to have your diagnostic studies reviewed by a physician? Call me today at 727-894-3188 for a complimentary consultation. If you have any questions about your rights to your disability benefits, 727-894-3188.